docket call. What's our status here, Mr. Gordon?
Your Honor, I met with my client again at some length this morning to discuss the plea offer that had been tendered. I've made it clear to him that he has two options. Option one being to set this for trial, or option two being to stipulate to remand to district court for entry of a plea to domestic violence. I asked him to think about it. Have you decided what you want to do?
Not yet. I didn't do it, and I didn't.
Have you decided what you want to do?
My mind is too.
Judge, could we perhaps hold this one over till after Mr.
Let's
Dewey's
pass the
sentence?
case. Let's pass the case. So just have a seat back in the courtroom, Mr. All right, and let's call people v. William Dewey for sentencing. It's file 23-93278FH. Counsel, you want to state your appearances on the record, please?
Zachary McLennan on behalf of the people.
Matt Boyd for Mr. Dewey, Your Honor.
All right, and we're here for sentencing after a jury trial conviction on a charge of accosting, 4-year felony, and use of a computer to commit that crime, 7-year felony, discretionary consecutive sentences. Advisory guidelines were scored at 0 to 17 and 0 to 11 respectively. Mr. Voigt, have you had a chance to review that pre-sentence report with your client?
I have, Your Honor.
Any additions or corrections to the factual information in the report?
A couple of fairly straightforward factual corrections first.
Okay.
At CFJ 101, under highest grade completed, it says high school diploma. Elsewhere in the PSIR, there's an indication that he received additional schooling at ACC and in a seminary. He has an associate's degree from ACC.
Okay, on page 8, H of the flesh of the CFJ 284, in the narrative about degrees, it says he did, states he did attend ACC and received an associate's degree in liberal arts. So I know you don't have any independent confirmation of that, but based on his report, can we change the basic information report and the CFJ 145 for education to state that it's associates?
Yes, Your Honor.
Okay. Mr. Boyd, any other changes?
Similarly, on CFJ 101 and on CFJ 145, there's reference to mental health treatment or psychiatric history. Both of those say no, respectively. And I believe elsewhere in the PSIR, there's indication that he's received mental health and psychiatric treatment in his history.
Your Honor, for that to populate, it's going to be actively in services and listed, and that's why that did not populate.
You wish,
Judge, I believe the record in the PSIR later reflects that he has had mental health and psychiatric treatment. If it only populates for active treatment, then I understand and withdraw that request.
it is a little bit confusing on the CFJ 145. It says psychiatric history. No, for that to only populate when it's not just history, but current treatment does seem strange. But there, the information is contained in the narrative portion, so we'll leave it as is then. Any other additions or corrections?
On page 8 of the CFJ 284, my client informs me there was additional substance abuse treatment for inpatient treatment at Bridgeport Reformers Unanimous in 2005. So we've asked that that be added.
That's Bridgeport what?
Reformers Unanimous?
Right, through
Unanimous?
That's
unanimous, it's Reformers Unanimous, and it was carried out through Bridgeport, First Baptist Church in Bridgeport.
Unanimous, not anonymous.
No, unanimous, yes.
I had the same question.
All right, an agent of the flesh, that information is always or usually self-report as well. Add that then.
Yes, Your Honor. And that was completed.
Was it completed?
6 months in-house, yes, sir.
Okay. All right, any other additions? Mr.
No additions or corrections, Judge.
Mr. McLennan, any additions, corrections to the factual information?
No additions and corrections, Your Honor.
Any scoring challenges from the defense?
Yes, Your Honor. With regard to the accosting count, OB 10 is scored at 15 points, and we believe it should be scored at 0. 15 points are scored when predatory conduct was involved. Predatory conduct is pre-offense conduct directed at a victim or a law enforcement officer posing as a potential victim for the primary purpose of victimization. In this case, the conduct giving rise to the accosting conviction is the same conduct that would give rise to a scoring. Most criminal sexual conduct cases or sex offenses involve enticing or soliciting or asking or encouraging an individual to engage in sexual conduct, followed by the sexual conduct. Here, there was a lot of talk. There was a lot of discussion by text message, and the jury found that that amounted to accosting. But that's not pre-offense conduct. That is the offense itself. And therefore, we don't believe that 15 points should score, nor that any should score at this point.
Mr. McLennan?
Your Honor, we can pair this together possibly. I was going to make an argument for OB 10 with regard to the computers using to commit a crime scoring scored at 0. OB 10 discusses if there is predatory conduct involved, of a vulnerable victim. In this case, Your Honor heard the facts at trial, the evidence. Believe there was a substantial amount, including prior to when he arrived at the hotel, including on his, he believed was a 15-year-old girl. I think that OB 10 was probably scored for the accosting charge. I believe it actually should have been scored 15 points. We were to commit a crime charge as well, Your Honor.
Thank you, Mr. Voida. Your response, any rebuttal or response then to the argument that if it scores for the accosting, it should also score for the computer crime?
For one thing, Judge, in order to determine whether there was an accosting, the factual determination needs to be made by the jury. They obviously agreed that there was an accosting, but they didn't have to agree upon when that occurred or what acts constituted that accosting. And so after receiving the text message response from the undercover police officers, those enthusiastic responses, arranging a meeting time, talking about a desire to engage in sexual conduct, et cetera, that itself can be accosting because it's enticing or soliciting a minor or an officer posing as a minor to engage in sexual acts, immoral acts. And so I maintain my position that that is the offense, or at least that there's a distinct possibility that those acts constitute the offense, not pre-offense conduct. Secondly, to the extent that we're using a computer to commit a crime, all of this happened through the use of a phone. And so by the very nature of the offense, using the computer to commit a crime, all of the text messages, all of the soliciting or enticing or that is done while using the phone. It's not before using the phone. It's through using the phone. And so it's not pre-offense conduct and should not score in that offense either.
Well, the guidelines allow it to be scored for a law enforcement officer posing as a vulnerable victim. And here there's a whole course of conduct of messages, they don't start right out of the gate of, hey, let's, I'm going to meet you at this time and place for sexual purposes. So I think there is, some pre-offense conduct necessarily, and certainly in this case as well, in the communications. I mean, for example, there certainly would be some of those initial communications that wouldn't have constituted a criminal offense. And so I think it is properly scored at 15 points for grooming kind of predatory pre-offense conduct behavior. So I'll leave OB 10 scored at 15 points for the accosting charge. And I do agree with the prosecutor that I think it also is properly included in the computer crime So we'll score OB 15 points, which brings the OB level to 2, and that would be 0 to 17 as well. Any other defense objections?
No, Your Honor.
Any other prosecutor challenges to this board?
No, Your Honor.
All right, Mr. Boyd, anything you want to say on your client's behalf?
Your Honor, you know that this is a case that went to a jury trial. It has gone up on an interlocutory appeal on the issue of entrapment, and it's going to be appealed after this sentence, no matter what the sentence is. I suspect Your Honor knows that the entrapment issue has recently been taken, the application was recently accepted by the Supreme Court, and that's an issue that's going to be decided by that court in the future. And I think you know that jurors were troubled by that issue underlying the case. It wasn't a basis to find him not guilty under the circumstances, and they found him guilty because he did something he shouldn't have done. He knew, he knows, he's aware that he should have had no business with someone, whether they were 15 or posing as a 15-year-old. And as this case is going to appeal, I don't want to say a whole lot more, but he accepts his responsibility for going farther than he should have on that day. We wouldn't have been here if after that phone call, he would have just said, not interested, and we would have been done. Now, his guidelines, as the court has calculated them, are 0 to 17 in both files. Those are intermediate sanction cells, and it starts with the notion that the proper sanction is one that doesn't involve jail time. Understanding that the court can depart from that if it finds reasonable grounds to do so. You've already done that by revoking his bond. He's already served 42 days as we sit here today. Couple of issues here. First off, during the time that he's been out, there have been no complaints, no issues, no bond violations, no problems. During the time that he's been incarcerated, the same thing is true. This is a man who's looking to get his life together, who knows that he made mistakes that landed him in this court, made bad decisions that landed him in this court. You have to decide what an appropriate sentence is for the offense and the offender. And in the world of accosting, this is about the least serious accosting you're ever going to see, because it didn't involve an actual minor child, because it did involve a guy who was at least trying at times to try to verify what was going on here. And there's no indication that there's any prior offenses like this. They looked through his phones, they looked through his devices, they didn't find anything in terms of child sexually abusive material or child exploitative material. The next question you have to decide is whether or not this is appropriate for consecutive sentencing. And I would suggest to you that it's not. Consecutive sentencing is discretionary with this court, and it has been on offenses involving a computer to commit a crime. When the legislature enacted that statute, that was at a time when you had to be much more sophisticated and you had to be much more capable of a criminal in order to commit a crime using a computer. It was before we all carried computers around in our pockets. And it's not as though he was using the computer in his pocket in a particularly sophisticated fashion. He wasn't accessing the dark web or doing searches or even hiding his identity. He was using a publicly available website, texting somebody through that website in a perfectly publicly available and legitimate way, and arranging a meetup in that way. There is nothing spectacular about his use of his cell phone in this case that would justify extending this to a consecutive sentence. And so, Judge, we would ask first that any sentence in this case be concurrent. And secondly, that any term of incarceration be limited to time in the county jail and as low as possible. Thank you.
Thank you, Mr. Boyd. Mr. Doobie, you don't have to tell me anything today, but you are allowed to make a statement if you wish. Is there anything you want to tell me, sir?
Yes, Your Honor, but I don't want to mess up my appeal.
That's why I say, say what you want, but you're not compelled to speak, and I don't hold it against you if you choose not to.
Biggest problem I've had in this whole situation is reproach on my Lord and Savior. I've been a Christian for a long time. I've had some issues. And walking around Gaylord in town, the gospel passing out, I've given over 400 gospel tracts and 300 New Testaments in that last couple of years. I'm known around that town, Bible built, that's the Jesus guy, Moses, whatever. I'm so ashamed of myself for getting involved in this. And even now, I've talked to 6 men in the county jail already about the Lord. I'm ashamed at having to have this on my record, but more that I brought shame to him, and it might be a stumbling block to somebody else. I'm just trying to get back on with my life.
All right, thank you, sir. Mr. McLennan, any recommendations from the people?
Yes, Your Honor. There is a lot to say here. I will try to keep it brief and summarize my thoughts on that. Reading the investigative report, one of the things that troubled me was it appears defendant did not take accountability for his actions for this offense. Maybe that's not the first time that's happened. The report indicates he was discharged from the Air Force for bad behavior. It indicates he stated he was set up. I see a trend or a pattern there potentially. As far as this case, again, Your Honor, listened to the facts and evidence as they were presented at trial. Disturbing to say the least. And this isn't a crime where, you know, it's just no harm, no foul. He thought he was going to meet a 15-year-old girl. It wasn't, and it was a decoy, but I would submit to Your Honor that he is a danger to the community. He was a little tepid at first about whether or not he should engage with the female, and eventually he decided and made the decision on his own accord to do so, and he went all in after doing that. He drove from Gaylord to come here to meet up with who he thought was a 15-year-old girl to have sex. That's a public safety issue, Your Honor. It's a danger to our community. I think under those circumstances, consecutive sentencing is very appropriate. And obviously his use of a cell phone was critical in order to carry out the offense. He sent explicit material to who he thought was the 15-year-old girl. He arranged the meetup location. He even made arrangements and stopped to buy candy and pop for her at her request. Your Honor, I believe discretionary consecutive sentencing, the consecutive sentencing is appropriate. Thank you.
All right, well, Mr. Doobie, you're 71 years of age. You're here for sentencing. You have 1 prior felony and 4 prior misdemeanors under the pre-sentence report. There's a couple things that are easy. There's $136 in state cost, $130 in crime victims assessment, and $350 in court costs that will be assessed in this file. I want to state for the record that the prosecutor says that I should take into account that you haven't taken responsibility for this offense because you exercised your constitutional right to a jury trial. I disagree with that assessment. And when somebody enters a plea to a conviction and then they try to come to sentencing and they don't take responsibility, then I think that certainly is valid for me to take into account. But you're entitled to maintain your innocence even today and take an appeal and do whatever you want for it. So I'm not increasing your sentence by even 1 hour because of your failing to take responsibility. Because this was a jury case. Also, in the question about discretionary consecutive sentencing, which does apply for the computer crime charge. And I understand where the prosecutor's coming from about, that this was a public safety danger, and I agree that it was. Your use of and I also, I may share some of Mr. Voida's, I guess, musings about the history of the computer crime statute and its wisdom today, but that doesn't really impact my sentencing decision about whether to apply the discretionary consecutive. What I'm looking at is, did your use of the computer make the crime itself more dangerous than it already was. And I don't think that this did. This wasn't something where your use of a computer made the situation worse. It was just part of what was necessary really for the situation. So I think when I consider whether to apply discretionary consecutive sentencing when the law in Michigan has a strong preference for concurrent sentencing, I think that there's an insufficient reason for me to apply consecutive sentencing. So I am going to order these sentences to be concurrent. But that comes to, well, what do we do? Both of them are scored at 0 to 17 months. The criminal justice reforms say that that's an intermediate sanction, so we can't impose any incarceration unless there's reasonable grounds for doing so. This is where then I disagree with something your attorney said. Your attorney said this is going to be in the world of accosting. This is among the least serious accostings you're ever going to see. I disagree. I tend to agree in this case more with the prosecutor that I think this is more toward the serious end of a scale on the accosting charge. If, for example, Mr. Doobie had simply communicated to an officer posing as an underage child to send him explicit photographs, that would be accosting. But here, Mr. Doobie wasn't just communicating with someone he thought was a child. He drove to a different county. He stopped to get candy for that child. If I'm remembering right, he got alcohol. Is that right?
That's correct.
Yeah, I thought I remembered that from the trial. He got alcohol for this, what he thought was a child, and showed up at a hotel room expecting and intending to have sexual intercourse with a child. That's a serious matter. I think that's a very serious accosting. And had that been a real child and not a law enforcement officer, there would have been a horrible event that occurred. Mr. Doobie's statements to the police upon his apprehension recognized that when he says he made statements about, oh my goodness, I'm so glad, that this was stopped. He said, I like to think maybe I wouldn't have gone through with it, but I don't know. He made statements like that. So I think it's a very serious accosting situation. And that Mr. Doobie, because he's willing to meet up with someone that he thinks is a child to have sex with them, while their responsible adult is off doing somewhere else and they're left alone at the hotel room, that's predatory conduct. That makes him somebody that the community has to wonder and be concerned about whether he's a safe person in the community. That's reasonable grounds for incarceration. And the 0 to 17 months allows me, without deviating from those guidelines, for a commitment. And I think on the whole, having heard the testimony at trial, that's what I'm going to do. So Mr. Doobie, I'm going to commit you to the Michigan Department of Corrections for a term of not less than 17 months, nor more than 4 years on the accosting, credit for 42 days previously served, and not less than 17 months, nor more than 7 years on the computer crime, credit for 42 days served. Those will be concurrent one with another. You have the right to an appeal. If you're entitled to appellate review of the conviction and sentence as a matter of right. If you are unable to afford a lawyer, I would appoint one to represent you on appeal, but you must file the request within 42 days after entry of the judgment of sentence if you want to appeal by right.
Judge, he's gonna fill it out right
You
here.
can also fill it out right now, and that will get that filed and we'll begin the appellate process right now. This is a sentence at the top of the advisory guidelines. I do think it's proportionate for the reasons that I stated. Let's go off the record for a second and can counsel approach on Mr. Paul.